The next case on the call of the docket is agenda number 2, case number 124744, People of the State of Illinois versus Miguel Deleon. Mr. Malamuth, you may begin.
Good morning, and may it please the court. I am Assistant Attorney General Eldad Malamuth on behalf of the appellant, the people of the state of Illinois. The issue here is whether it violates procedural due process to issue a no contact order that restrains a defendant indicted for a sexual offense from contacting the victim. The circuit court found the statute unconstitutional on its face because it did not require testimony and cross-examination of the alleged victim. This court should reverse because it does not violate due process to, based on a criminal indictment, restrain a defendant's rights to contact the alleged victim. This is true whether we apply the test for statutes governing the criminal process set forth in Medina versus California, or the test for deprivations outside the criminal process set forth in Matthews versus Eldridge. But in this case, the criminal Medina test should apply. Article 112A, in which the statute is found, is part of the Code of Criminal Procedure under Title IV, Proceedings to Commence Criminal Prosecutions. The purpose of the article is so that protective orders can issue as in conjunction with criminal prosecutions, and so that victims can avoid the trauma of attending multiple civil court proceedings. The protective order hearings occur at the criminal case hearings. The service of the petition occurs at the criminal proceeding. And so the case is intertwined with the criminal process and is in fact part of it. And therefore Medina should apply. Now, in matters of criminal process, the statutory procedure violates due process only if it violates a principle of justice so rooted in the traditions and conscience of our people as to be ranked fundamental. But here, it does not violate such a principle to restrain a defendant's right to contact the alleged victim, because as defendant himself admits here, that's already done by the pretrial bond release conditions. So defendant has conceded that based on the criminal indictment here, the pretrial release conditions restrained him from contacting the alleged victim. And so the fact that the no contact order did so as well cannot violate a principle that is so fundamental to our system. So under the Medina test, which should apply, the statute passes constitutional muster. That is true as well under the Matthews test. Again, Matthews is a balancing test which applies to deprivations outside of the criminal process. And the United States there set forth 3 factors to help decide whether there's a meaningful opportunity to be heard at a meaningful time. Those factors are 1, the governmental interest at stake, 2, the private interest at stake, and 3, the risk of an erroneous deprivation of that private interest and the probable value, if any, of the requested procedural safeguard. So taking the factors one by one, the governmental interest, the first factor, is substantial here. Of course, there is the interest in protecting an additional traumatic hearing for the victim. And there's also the interest in protecting the victim pending trial, and in doing so, without having to conduct a mini trial, which would, of course, not only be a substantial outlay of resources, but would preview the prosecution's case, which would make obtaining convictions more difficult. Turning to the second factor, the private interest at stake. Here, because defendant has already conceded that he was restrained by the pretrial bond conditions, in much the same way as the no contact order, there really isn't a substantial private interest. And finally, turning to the third factor, the value, if any, of the requested procedure, which is the testimony and cross-examination of the alleged victim. Now here that would do little, if anything, to safeguard against erroneous deprivations, because the deprivation is erroneous only if the prosecution couldn't establish probable cause. But as the United States Supreme Court made clear in the Cayley case, the testimony of the alleged victim is going to do little to change that, because probable cause only requires a fair probability for on which reasonable people act. It requires only that a prudent person believes there's a reasonable possibility that a crime has been committed. And so there's no need for any kind of final credibility determination. And the probable value of a testimony of the alleged victim is going to not impact that.
Counsel, if I may ask, does it make any difference that in Cayley and some of these other cases you're talking about seizure of assets versus protected liberty interests?
No, Your Honor, it doesn't make a difference. In Cayley, the interest at stake, the claimed interest was not just seizure of assets, but the desire on the part of the criminal defendant to use those assets to hire an attorney. So there was a substantial interest there. And in fact, there the court acknowledged that if the assets were frozen, that might impact the ability of the criminal defendant to hire counsel of choice. Here, by contrast, the defendant has conceded that his rights are already restrained he's already restrained from contacting the victim. So the private interest at stake here is actually less than in Cayley.
Thank you.
Here's a follow-up question to that. Does the fact that an indictment has been returned against the defendant play into this?
Absolutely, Your Honor. In this case, once again, as Cayley discusses in depth, the criminal indictment is a long-standing and established part of the criminal process. And that allows many things to occur. It allows, as Justice Garmon alluded to, the seizure of assets that might be forfeited. It allows, of course, the restraint of a criminal defendant's liberty to potentially move around. It allows the government the ability to obtain a buccal DNA swab. And so a criminal indictment is a long-standing truth in our system that it allows all sorts of restraints. And so a criminal indictment here only establishes that restraining a defendant's rights, which again, already done so via the pretrial bond release conditions, are permissible. And so the statute here is constitutional under both the Matthews test and the Medina test. And so this court should reverse the judgment of the circuit court, finding the statute unconstitutional. And unless
Mr. Malamuth, defense seems to, I think, argues that it was not necessary for the trial court to consider the constitutionality of the statute because the state got all of the relief it sought in the conditions of the bond. First of all, do you agree that the state got all of the relief it sought in the bond restrictions? And second, what about the necessity of reaching a constitutional issue?
No, Your Honor, we disagree with that assertion. The state and the victim did not obtain all the relief that it requested. From the perspective of defendant, it is certainly true that his rights were restrained in much the same way. but from the perspective of the state and the victim, that was not the case. And so there are advantages for the victim to get a no contact order as opposed to defendant simply being restrained on the pretrial release conditions. Those advantages include the entry of the existence of the no contact order in LEADS, the Law Enforcement Automated Data System. It includes the ability to enforce the no contact order outside of Illinois. It includes the ability for a police officer to conduct a warrantless arrest if there's probable cause to believe that the no contact order has been violated. And it also may be enforced in criminal courts in ways that the bond conditions may not be. And so we don't agree that the state received all the relief that it sought. Moreover, the statute is mandatory, does not permit the circuit court to decide not to enter the order based on this alleged redundancy. And finally, even if that were the case, which it's not, but even if that were the case, the answer wouldn't be to simply leave that order finding the statute unconstitutional in place, but the answer would be to vacate that order and to remand for the denial of the petition on other grounds. And so the judge was correct in determining that he had to find whether the statute was unconstitutional, but incorrect in determining that the statute violated due process. So unless there are other questions from the court, we ask that this court reverse the judgment of the circuit court.
Thank you, Mr. Malamuth. Mr. Blood, you may proceed.
Thank you, Your Honor. Can you hear me all right?
Yes.
Thank you. May it please the court, I am Curtis Blood, and this court appointed me to represent Miguel Deleon. This court should not decide this constitutional issue. The outcome of this appeal will not affect Mr. Deleon. This court can affirm, reverse, or dismiss, and it's all the same to Mr. Deleon. The trial court gave the state every single bit of concrete relief that the state asked for. So if this court reverses and remands, there's nothing more for the trial court to do to my client on remand beyond what the trial court has already done.
So you're saying, may I say this, sir? You are saying that a condition of bail bond is coextensive, has the same impact as the granting of the statutory civil no contact order in the context of a sexual crime. You're saying they're exactly the same thing.
Your Honor, I'm saying that if my client contacts the complaining witness, my client is going to jail. My client won't care what color the paper is that lands him in jail, won't care what the heading is on that piece of paper. He's in jail.
Well, how about the alleged victim in this case? We understand that when someone is released from the jail, they get a bond slip and they take it home with them, and it has conditions on it. The statute that we're talking about has very specific notice requirements to the person who's to be protected, the alleged victim. That person needs to have the actual document, the order, the idea being that if the defendant were to have contact with the alleged victim, that you could call the police. Here's the order. And as we've indicated, the statute says that if the person comes to have contact with her, they could be arrested without a warrant. I mean, there are a number of sections in the statute that are there to protect the alleged victim in this case. And most importantly, of course, there's the penalty specifically for violating this kind of order, not bail bond, but this kind of order that is either a misdemeanor or on the second time that what might happen, a felony. I mean, are they very different?
On the last point, first, Your Honor, if I may, certainly there is a penalty difference. And if my client were to contact the complaining witness and were to be arrested for that as a separate charge, brought to court, convicted of a separate offense, then this case would, the constitutional issue would be before this court. But at this point, it is not. At this point, nothing has changed. Nothing changes for my client other than the fact that he is prohibited by the order of the court. The court has entered an order. It simply hasn't put the heading on it that the state desires.
So is it, counsel, is it your argument that it's redundant?
Oh, absolutely, Your Honor. That is my argument, yes.
Should we be looking at how the two different orders affect the alleged victim in the case? Or should we just be looking at how they affect the defendant?
Your Honor, I'd submit that it's more fundamental than that. The state, in its motion, requested 4 specific pieces of relief. The circuit court, Judge Hill, granted all 4 parts. And that should be it. The state asked for things, the state got those things. That should be the end of it.
Was the victim served with anything? Was the victim served? As the statute regarding the no contact order requires notice to the person who's the order is aimed to protect.
I don't know, Your Honor. I don't believe the record speaks to that, and I don't know.
Also, in case that the clerk of the court shall, on the same day that a protective order is issued, file a copy of that order with the sheriff or other law enforcement officials with maintaining the Department of State Police, etc. So there are provisions in the statute that go beyond the bail bond, certainly.
There are, Your Honor. But the fact remains the state has received what it requested. It may be that the state has, but this is basically a redundant statute, and that the legislature is entitled to enact redundant statutes. That's up to the legislature. But this court has its own rules on when it considers a case, when it considers a constitutional issue. And the fact remains that in this case, the state has made its requests for relief, and the circuit court, Judge Hill, has granted those requests. And that, under the rules of this court, is not something that this court then takes up. The rule, and I've seen it in several cases, but I've cited one of them, is just because the case comes to this court on account of a ruling of unconstitutionality does not ipso facto mean this court has to take up the constitutional issue. It remains the case that my client has been saddled with all of the prohibitions that the state asked Judge Hill to order. Every one of them.
Mr. Blood, are you saying that your client's constitutional rights haven't been violated?
I'm not conceding it, Your Honor. I'm saying that it doesn't matter to him whether they have or not. Okay. That in this case, if they have, if they haven't, the order is the same. The prohibitions ordered by the circuit court are the same. That's all I'm saying. I think the court understands my position on why it shouldn't take up this issue, the constitutional issue. I'd like to go on to the matters of leads and the full faith and credit clause. Now, the state has pointed out that full faith and credit, there's an enabling statute for the no contact order, and there's not, that's, well, for bail bond conditions. Two things. First, that was not raised in the trial court. Second, even if it had been, the full faith and credit clause does not need an enabling statute. It says what it says. It's our Constitution. As for leads, again, not raised in the trial court. Could this have been issued? Could this have been listed in leads? Could this have been entered in the database? We don't know. We continually see the state in this case not want to talk about the order at page C81 of the record. It's an order. Is it protective? Yes, it is. What is an order that's protective? It's a protective order. Page C81 is a protective order. It's not under the statute that the state seeks to have it entered under, but it's a protective order. Could it be entered in leads? Could Judge Hill order the police to enter it in leads? We don't know because nobody mentioned leads before Judge Hill.
It doesn't, I just read you the section of the statute that says when the court enters the order, and of course this is a mandatory statute, when the court enters the order, the clerk of the issuing judge shall on the same day that a protective order is issued, file a copy with the sheriff or other law enforcement officials charged with maintaining the Department of State Police records, service by the sheriff, I mean, according to the statute at least, this kind of order triggers immediately the involvement of law enforcement. So I mean, I'm not, as well as other protections. There are a number of other protections in the statute that are not contained in the conditions of bail bond. I mean, I understand that the state brings up this idea, leads the database, but the statutory language is all about how the order, the statutory order that's mandatory has to be then filed with the law enforcement. And then we know what flows from that is that if in fact the alleged victim contacts the police and says that the respondent has had contact, the police then no longer need probable cause to arrest. That's how the statute is set out.
Your Honor, I think you're making a much better argument for the state than the state made before Judge Hill. That none of this was brought up to Judge Hill. And it'd be interesting to see what he would say if it was. It might have changed the case entirely if he'd been presented with the arguments he was never presented with. But the state gave him a laundry list of things that it wanted my client prohibited from doing. And Judge Hill prohibited my client from doing all of them. Then the counsel for the complaining witness suggested there was a problem that the conditions of bail bond did not name the complaining witness so that she could take it and say, look, I'm protected. And the judge entered that.
Did she get a copy of the bail bond slip that had her name on it?
The record does not say, again, that's page C81 of the record. Anyone could have handed it to her, but the record does not reflect whether that was done. I don't know. But back to my point, I hope I've answered your question, Your Honor. The judge was very accommodating to the state. I mean, not only hit the laundry list, but also, oh, you want the complaining witness's name added to the conditions of bail bond? I'll do that too. Then the state was silent at that point. I mean, other than The fact that the statute was being held unconstitutional and the state didn't want that, if there was no other concrete relief requested, and then the judge had done the whole laundry list and then some. What would Judge Hill have done if these other arguments had been made? What would Judge Hill have done if more had been requested? We don't know. But there's a way of deciding these cases. We can, at this point, bushwhack Judge Hill. But Judge Hill was presented with a concrete list of requests and he granted them all and then some. Is it time to bushwhack Judge Hill? I don't know that it is. Under our rules, I don't think that it is. Thank you.
Any more questions? Mr. Malmuth?
Thank you, Your Honors. Just a couple quick points. First, the defendant never suggested below that the judge should deny the protective order petition based on this alleged redundancy. So any failure to discuss the relative advantages of protective orders versus bail bond conditions was purely the result of the defendant's motion. In defendant's motion, the only grounds that defendant provided the judge to deny the protective order was the alleged unconstitutionality of the statute. So to come up now and somehow complain about the lack of a record on the advantages of protective order versus bail bond conditions put forward by the state, that's simply a result of the grounds offered by the defendant. In any event, though, that the record does contain the advantages of the protective order statute. And as discussed, even if defendant were correct that the judge could deny the motion based on redundancy, which again, he could not because it's a mandatory statute, then the answer wouldn't be to leave the order finding the statute unconstitutional in place. It would be to vacate that order and then to remand for further proceedings in light of that. But turning towards the merits, it's again notable that defendants repeatedly does not contest that his rights, from his perspective, the protective order did not additionally restrain his rights. But as Justice Tice noted, there are many advantages for the victim and for the state, whether it's enforcement, whether it's notice to the victim and to law enforcement. The advantages are multiple. And so there was good reason why the state wanted a protective order. There's a good reason why the victim would benefit from a protective order. But because, and as defendant has pointed out, because it didn't restrain his rights, there are many good reasons to hold that the circuit court was incorrect in finding the statute a violation of procedural due process. So unless the court has any further questions, we would ask this court to reverse the judgment of the circuit court.
Any more questions? Seeing none. Case number 2, number 124744, People of the State of Illinois versus Miguel Deleon, known as agenda item number 2, will be taken under advisement. Thank you both very much, Mr. Malamuth and Mr. Blood, for your arguments this morning. Thank you.